Please be seated. We will hear argument in case number 240840 DV against the Texas Department of Family and Protective Services.
May it please the court, Mr. Rowans will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Chief Justice. May it please this honorable court. The issue this morning in this case is whether or not the Texas Department of Family and Protective Services abandoned its cause of action to terminate respondent mother's parental rights when the department's caseworker, who was its designated representative, testified at trial that the department was not seeking termination of respondent mother's rights. We feel that the answer to that question is yes. The department did abandon its termination cause of action, and therefore the Court of Appeals erred in not reversing the trial court judgment because the trial court judgment of termination was not supported by the pleadings.
After that happened during the trial, did the trial go on as if both parties needed to present whatever they were going to present anyway?
Well, the Court of Appeals, on page 4 of their opinion, states that due to the actions of the parties and the participants at trial, the Court of Appeals was unable to interpret the department's testimony as an unequivocal abandonment. And so I think that's an error. The actions of the department were necessary to support the only relief that the department was asking for, and that was to restrict and limit respondent mother's parental rights to that of a parent non-conservator.
Go ahead. On that, what is the father's position? Because it seems like there are interests other than the department at stake here because of the father's position as conservator of the children, and his father, its father and grandfather.
Well, true. The child was placed with the paternal grandfather when this case started. The department wanted the father to be the managing conservator of the child. That was their request to the court, was to name the father as the permanent managing conservator and name respondent mother as a parent non-conservator. Now, the father did not have termination pleadings on file, and the father's testimony at trial was that he didn't really want to co-parent. That was his testimony. He never specifically asked for termination, nor did he have pleadings on file. And the fact that he didn't have pleadings on file is very significant because 4 other courts of appeals in the last 5 years have heard cases that are exactly similar to this case.
In what way? What do you mean?
Well, in 2020, in Amarillo, in Ray TM, termination pleading was filed by CPS against the parents. At trial, CPS's position was do not terminate. The mother in that case asked for termination, and the trial court terminated father's rights. Father appealed. The Court of Appeals strictly scrutinized that record in favor of the terminated parent and found that the department took the position at trial that they were not seeking termination, so they abandoned that cause of action.
And there were no other pleadings on file that were
No other
requesting
pleadings on
that
file,
family.
and therefore the termination judgment was not supported by the pleadings. San Antonio, 2021, same fact pattern in 2021 in Ray EH. Termination pleading filed by CPS against the parents. In that case,
Okay, let me ask you a question. So let's say if the facts were such that in this particular case, it wouldn't be terribly devastating for this particular child because the child is with the father and the paternal grandfather, and it's not as if whatever happens here with regard to the mother is really going to change that, or it's not like the child is going to go back to a seriously abusive parent, or that adoption is going to be blocked. But of course, we have to look at other cases. And let's say if there's other cases where, a caseworker may inadvertently say something that could be taken as abandonment. Can you think of a limiting principle that we could perhaps pronounce so that in those situations where the ramifications could be different than they are going to be from the record, what it looks like here, that we could maybe limit that? Have you thought about that?
Well, I have thought about that, and the courts of appeals cases that I'm talking about, there's one from Amarillo in 2020, there's one from San Antonio in 2021, there's one from Fort Worth in 2022, and there's one from First Court in Houston in 2023. The department's position in all of those cases, just like the department's position in our case, was unambiguous. They were not asking for termination. There are other cases where a comment by the department's attorney in opening or some other testimony made the request a little bit ambiguous, and therefore the Court of Appeals did not find that there was an unequivocal abandonment. In the cases that were cited to the Court of Appeals by respondent mother in our case, the ones I'm talking about, the position is clear, just like the position was clear in our case. And so I don't think there needs to be any limiting language, because if it's clear, it's clear. If it's ambiguous, then it's not an abandonment.
Should we take into account, as we think about this, that the department always pleads termination in every CPS case, and then sort of, that's just their practice. They plead everything, up to and including termination, even if the case obviously doesn't merit termination, and then they sort of go from there and they decide what their goal is going to be, and they may ultimately not pursue it, but that's their practice, is to just always put that in the pleading. And so should we take that into account as we think about this question?
Well, yes. I mean, the department cites the statutory admonishment that is required of every parent during these statutory hearings, and that admonishment is your parental rights could be further restricted or terminated. And in all the pleadings that CPS files in these cases, they plead for termination, and they plead alternative relief of limiting parents' rights and restricting those parental rights to overcome the two presumptions in the family code that they need to overcome in order to seriously restrict parents' rights.
And so if the question is, if you're on notice that they're seeking, are you on notice that they're seeking termination?
Yeah.
The existence of that statement in their pleadings doesn't put you on notice, I wouldn't think, because it's just so pro forma in every single case that they file that it's not really telling you anything other than that CPS is after you.
Well, recently with some legislative changes, there's been more cases, more lawsuits filed by CPS when they're not seeking termination. Those are called court order services cases, where they're asking the court to order the parents to do services without removing the children from the parents. So there's a different type of petition that CPS can file. When they do file a termination pleading, there's no question. They're form pleadings like everybody uses, and the parents are on notice of what is at stake in these cases unless they change their behaviors.
Can you help me understand, what is the difference between termination and what the caseworker testified? They said seeking to limit and restrict mother's rights and give permanent managing conservatorship of child to person, and to limit mother's rights to parent non-conservator with no visitation and contact. What are the kind of the differences between termination and that?
Well, the primary difference between termination and naming a parent as a parent non-conservator is the parent who's not terminated has the right to file a lawsuit to amend.
Okay.
And that's the primary.
And then just two other questions here. So I think that this was you in the trial court. I'm asking the court not to, are you asking the court not to terminate your parental rights? And mother said, I'm asking the court not to terminate my parental rights, yes. And then when it's time for closing, I think he said, Your Honor, I would just ask the court not to terminate mother's rights. So do either of those statements indicate that everybody was on notice in the trial court that termination was potentially on the table here, since you're asking, like, don't do it?
Everybody was on notice.
Okay.
There's no doubt that we were on notice that respondent's mother's parental rights could be terminated. However, when CPS testified, they testified they were not seeking termination unequivocally. And the questions posed by the department's attorneys, not only to its designated representative, but to other witnesses in the trial, clearly indicate that they were developing evidence to overcome the presumptions in order to restrict respondent's mother's parental rights rather than to terminate them. And so the fact that I echoed in my closing remark to the court not to terminate respondent mother's rights, that I echoed the request that CPS was making didn't change CPS's position and didn't change the request that CPS was making of the court. And
If this were a case involving TxDOT and a peace officer testified in connection with the lawsuit against TxDOT and said, TxDOT's not seeking the relief that TxDOT was claiming in the lawsuit, would the peace officer's statement constitute an abandonment of the pleadings by TxDOT?
It depends on whether the role of that witness.
So your point is a state employee who's designated as the representative of the organization, then during his or her testimony has the authority to abandon the pleading?
They had the authority and responsibility to articulate to the court what the entity was asking for. And not only do you look at her testimony, but the Court of Appeals said they were looking at the actions of the parties, and that includes the actions of the attorneys. And if you look at the wording of the questions of the department's attorneys, the department attorney never asked any witness if termination was in the child's best interest. The department's attorneys asked questions regarding the contact between the mother and the child, whether contact would significantly impair the well-being of the child, and that language is straight out of Family Code 153-191, which is
Your point is it was not just a caseworker, it was also counsel for the department.
Well, they were
that indicated that they were pursuing something less than termination.
correct. Another department employee was called. That employee was a courtesy worker, who was a caseworker in another county, and the department's attorney didn't ask that caseworker either whether the department was seeking termination.
So if all those things had happened and the questions seemed so focused not on termination but on non-conservator parent and all the rest of it, but there had never been the statement, we're abandoning it,
Correct.
what then?
Well, according to those other Court of Appeals cases, there doesn't have to be a specific statement.
Well, I thought you said those other ones, it was unambiguous that they were abandoning it.
Well, it was unambiguous, yes.
So in my world, everything in your trial happened just the way it did, and it would be very easy to look back and say, well, the reason they asked those questions and not these is they're looking for this. But nobody, the designated representative, the lawyer, nobody ever said, we are abandoning, we are not seeking termination. If that never was said, and then the judgment came out the same way, I suppose you could challenge the adequacy of the evidence for the best interest finding or whatever, but would you be in a position to say it was abandoned?
I think you are. When they don't, when the requested relief and the department's position as articulated during trial is that they are not seeking termination, that's a
But I'm saying that didn't happen. That is not what they said. I'm giving you a parallel universe.
Okay, I'm sorry.
Your same trial, except they never did say we're not seeking termination.
Well, if the department testifies about that they're not, I'm sorry, in your hypothetical, you're saying that nobody says, I'm not seeking
Yeah,
termination.
they still ask the same questions, they still get the same evidence, all that stuff, but they never say, the department's not seeking termination. Everything else is the same. Can we say as a matter of law that it's been abandoned? It's in the pleadings.
I don't think you can say as a matter of law, it's been abandoned. But
So suppose then that the statement did happen just the way it did, everything else happened just the way it did, your actual trial, except that the lawyer, at some point, maybe shortly after the statement was made, she says, Your Honor, I just want to clarify as counsel for the department, we are not abandoning the termination request. What then?
Well, that certainly would make the position ambiguous, and there would not be an abandonment.
All right, so then the question is, does there need to be something if you or counsel in your situation say to the court, Your Honor, termination has been abandoned, it's off the table, please don't consider that and confine it to this. Would that not provide the opportunity for absolute clarity as opposed to by accident or whatever else? And so what I'm getting at is, when Justice Lehrman asked, what is the principle that we can articulate? There are a whole bunch that are floating around, and one of them is we're trying to make sure that these things happen because they're real and not by accident. Is there some duty on the part of counsel for the parent to do something to make very clear, raise an objection if the court proceeds or whatever? As far as we're concerned, termination is off the table, and if there's nothing from the state at that point, you're probably home free. What is your response to that?
Well, I think we were home free because we were allowed to rely on the testimony of the department's representative. That testimony was an admission in a judicial proceeding regarding a matter incident thereto, which is a stipulation. And this court has held in Shepherd v. Ledford that a party is stopped from arguing contrary to a stipulation made.
I still want some clarification. I'm sorry, did you have something else? Yeah.
And I don't want to stop that, but just to be clear, I'm understanding, are you saying then that it's the reverse duty, that if that sort of a stipulation is made, then it's not the duty of the lawyer for the parent, it's the duty of the lawyer for the state to step up and say, Your Honor, just to be clear, termination is still on the books, on the table, whatever?
I think that's right. I think the department and their attorneys have an obligation, not only to the other parties, but to the court, to articulate their requested relief to the court. And if they are asking the court not to terminate, and there's no ambiguity in that testimony, which there wasn't in here, and there's no opening argument or closing argument or other request by the attorney about termination or is termination in the child's best interest, then that would make it ambiguous. But if the department or the attorney never do that, the other parties can rely on that, and I do think it's their duty to make that relief clear to the court.
My question has to do with Justice Bland's question, I think, and that is as far as, you have a caseworker, but I don't know that the caseworker has the authority to speak for the entire department. And so what was your answer to that?
Well, the caseworker was identified by the department's attorney as the corporate representative, as the designated representative of the department, so they did have authority to speak.
So that question was
Yes.
was made clear.
Your Honor, I see I'm out of time.
Any further questions?
Well, I just want to make sure I understand, if we agree with you, what exactly should the judgment be?
Well,
Should we send this back to the trial court? Do we give directions? Can we render for some lesser thing? The thing that you think they were actually seeking obviously was not.
I think the request of this court is to reverse the Court of Appeals and the trial court judgment because the termination judgment was not supported by the pleadings, and render a judgment naming respondent mother as a parent non-conservator, which is what the relief that was requested and the evidence that was developed at trial.
We can render that judgment, you think?
I believe you can.
And the father will be okay with that?
I'm not here to represent the father. I don't know what he would agree to or not.
But on behalf of the mother, she'd be okay with that judgment?
I believe she would. That's what was argued and requested, and she did a remarkable job in the last few months of this case to turn her life around, and I think she deserves that opportunity to have a relationship with her child in the future.
Thank you, counsel.
Thanks.
We'll hear from the respondent.
May it please the court, Mr. Plemons will present argument for the respondent.
Mr. Chief Justice, may it please the court. Mother never appealed the sufficiency of the evidence supporting the termination ruling in this case. Instead, she asked for reversal on one purely legal ground: abandonment. The court should not reverse. It should affirm for two reasons. First, everything in the record, save for 7 lines on the transcript, confirms that the department never abandoned its termination claim. And second, even if abandonment occurred, termination was still tried by consent.
Did the department decide after the trial that it thought termination was good because that's what ended up happening, or why the change of heart?
I do not believe that there was a change of heart, Your Honor. As one of your colleagues observed, caseworkers do not have the authority to single-handedly and irrevocably abandon a claim that the department has steadfastly
I think the argument is that
litigated.
it's irrevocable, right? The argument seems to be the lawyer could have gotten up and revoked it, but didn't, and so it wasn't argued. What's wrong with that rule? If the rule is, somebody says we're not seeking termination, okay, well we're going to enforce that, but if somebody else gets up and rehabilitates that, and it's in the pleadings, then of course it's back on the table. What's wrong with that rule?
I think that it allows for claims to be abandoned even when the department continues to move forward with presenting evidence in support of termination, like when the department, immediately after the caseworker called the court-appointed special advocate and elicited testimony that termination would be in the best interest of the child. As the Third Court of Appeals observed, presenting this sort of evidence is inconsistent with the idea that the department abandoned its claims for termination in this case.
Do you agree that the caseworker in this case was the designated representative for the department for trial?
I believe that
And thus had the authority to opine on the relief that the department was seeking?
No, Your Honor. While she may have been a designated representative, it was really only, and as the other side cites the rule, it was only for the purposes of sitting in, offering testimony, and not having to exit for the rule. This court has held in several contexts that while government employees can represent the government in certain capacities, that doesn't necessarily mean they have the authority to bind the government and others, like the sovereign immunity capacity or sovereign immunity context, estoppel, etc. And here, these sorts of employees, like caseworkers, simply do not possess this sort of authority. The way the department determines whether or not to abandon pleadings is to get together with the caseworker supervisor, and at least one department attorney, and that decision is made collaboratively. It has never been the department's view that a single caseworker possesses this sort of authority.
So this really only comes up in bench trials, right? Because in an ordinary civil case, you can plead for whatever you want, but if you don't submit a jury charge question on it, you've abandoned it. And so should parents always request a jury trial to be clear about what the department's intentions are, or what would you advise?
Well, parents are always free under the family code to request a jury trial whenever they want. And if they are truly worried about abandonment issues like these and they really want to be careful of that, they can request a jury trial. But that did not occur here, Your Honor.
So there's nothing in the record about what the department would have submitted as far as jury charge questions if this had gone to the jury, I guess?
No, Your Honor. This has been seen as a bench trial from the beginning.
Am I correct that it's the standard practice for the department, anytime a child is removed, to plead for termination in the initial pleading, even if they have no idea whether they're going to seek it or whether it's appropriate? They always plead termination and then hold that over you, rather than waiting to see whether that's what they're going to pursue and amending their pleading to include it. Am I right about that?
I think that was a correct statement for a period of time, but as my friend on the other side observed, things have changed, and there are instances where termination is not pled. So it gives all the more weight to the written pleadings.
Even when the child is removed?
Yes, I believe so.
If you would let me know the department's practice on that. When the child is removed, is termination pled as a matter of course? I'd like to know the answer to that.
Yes, to my knowledge.
And an addendum to that would be, is that ethical? If no one's really analyzed or thought much about whether termination is an appropriate remedy at that stage of the case. I'd like the department's position on that.
To my knowledge, my apologies, it looked like you were.
I was just going to say, in relation to that question, I would be interested in the department's policy on removal when termination is not at issue. It would seem to me that it could be very possible that the reason that when children are removed that termination is requested generally is because the findings are similar. Because removal is not just done willy-nilly by the department.
No, of course not. Removal and most certainly termination are very serious claims to bring, and as the record showed in this case, clear and convincing evidence demonstrated that it was merited.
So it's such a serious thing to ask for termination that we have repeatedly said in so many different ways. It's the ultimate last resort, the civil death penalty. If there's any doubt in construing the statute, we resolve it in favor of the parents just over and over again. And it just seems to me possibly true that in a situation in which you have the designated representative say, no, we're not seeking termination, that all of those principles say, well, it can't possibly, as a matter of law, really be the last resort if there isn't an unambiguous statement. No, that is on the table. This is what we're going. It should be an opening argument, should be a closing argument, should address to the judge. Statement like that should be corrected. Does that not seem like a pretty modest thing to ask of the government of our state before it permanently terminates the most precious right that anyone has to their children, to at least be unambiguous about that and not rely on stitching together a few things when you have what would be an unambiguous abandonment if that were all we heard?
Well, Your Honor, like you said, this court has really held that termination is the civil death penalty and is very serious, but also serious is the best interests of the child. But going to your point on ambiguity.
Was that ever argued in the hearing?
The best interest of the child?
Your colleague said it wasn't.
Well, it was certainly testified to by the attorney ad litem. She stated that termination would be in the child's best interest and that she believed the department carried its burden to prove that termination was appropriate in this case.
And then she immediately carried on and said, but of course, if the court doesn't do that, then non-conservative parent is fine, and that's the attorney ad litem. I'm talking about the state of Texas.
Yes, the attorney ad litem was saying that in the alternative, but you are correct. The department trial attorney did not offer opening or closing argument in this bench trial.
So if we were expecting the government of our state, on behalf of the people of our state, to take away someone's child, would it even be too extreme of a thing to say, if you don't, in opening or closing statement, make clear you're terminating parental rights, that's off the table? I'm not saying that this case requires that, but that doesn't strike me as all that extreme of a thing, the most modest thing imaginable. Just make it clear to everybody, the state of Texas wants to sever in a legal way this most basic of human rights.
Well, clarity in this case would have certainly helped on either end, but this court has denied petitions in cases where termination was not even in the written pleadings. For example, in Ray AJB was cited in the response, and there termination was not.
I mean, the denial of a petition is meaningless. There's nothing that you can draw from that in terms of the court's view of the law. There can be a number of reasons, procedural, substantive, whatever, that the court's not going to take up a case on the merits. Just as a legal principle, why, given all of the guardrails that the court has tried to emphasize over and over and over again, why isn't this kind of an easy case? When we have a statement like that, we just take up. And of course, if there's ever some circumstance in which termination becomes necessary, even if she's just limited to non-conservative parent, the state is not, there's no res judicata to stop them from proceeding again. But why would we have this irrevocable thing happen under these circumstances, given the repeated admonition that any doubt, any ambiguity, all of that cuts in favor of maintaining the parental link, at least as a legal matter. I'm not saying we put the kid back with the mother, anything like that, but just as a matter of having the status of a parent, to terminate that in the face of ambiguity or doubt is something that seems foreign to this case, this court's cases, and I'd like your response to that.
Yes, Your Honor. Well, I think that really interplays with the test that courts, intermediate courts of appeal who have evaluated abandonment in the vacuum of precedent from this court, clearly articulating the standard for it, have made looking at the broader scope of what has happened in a trial deeply important to determining whether or not claims are abandoned. And perhaps in a termination case there is something more, but also the department as a state entity has a very vested interest in being able to continue litigating its cases, and its caseworker had no authority whatsoever to abandon that claim.
When was the issue of abandonment first raised? So in connection with the judgment, in connection with findings of fact, on appeal, when did this all become an issue for the department?
I believe that it became an issue after this case was sent back down from the Third Court of Appeals the first time, Your Honor.
So if we require in the jury charge context, we say, in a jury trial context, we say it's not enough to plead it. The person who is seeking that relief, the plaintiff, has a burden to request a question on it and get a submission to the jury on it. Why is it not fair then in the bench trial context to put the same burden on the plaintiff to say, if your corporate rep says we're not seeking that, why isn't it fair to put the same burden on the plaintiff that they would have in a jury trial to say to the court, actually, Your Honor, we are seeking that, so that the judge knows what's in front of him or her for the bench trial and can decide those questions?
Well, Your Honor, there's a difference here between a private corporate representative and a public representative of the state. As we discussed earlier, this court has held several times that while a representative of a department can testify to some things and can bind the department in some ways, there are certain things that are reserved for the state itself, and that a single employee who the department has never viewed as having the power to abandon steadfastly litigated claims can.
But the attorney certainly did, and the attorney didn't contradict that representation.
That is correct. He did not go on to ask any clarifying questions in the record, but instead offered evidence of termination after the caseworker testified as she did.
If you were representing the parent, do you think that, and this happened, do you think that the department's lead witness getting up there and saying, we're not seeking termination, their lawyer not rehabilitating that or contradicting that, might that affect the way that you put on your case and the way that you cross-examine the witnesses and the way that you make your argument, given what's been represented about what's at stake?
Well, in this case, it did not seem to do so. The mother expressly requested that no termination.
Well, my question wasn't whether it did in this case. My question was, I mean, it seems to me naturally that it might very well affect the parent's attorney's presentation of his or her case, and I'm wondering if you see that.
I can acknowledge that in this hypothetical case, an attorney might be affected by that. But I imagine that this hypothetical attorney would also try to object when a termination ruling came up and say, no, that was abandoned. That is no longer live and active. But that's not what happened here, Your Honor.
Well, thinking about this case, but also the many, many other cases like this that do not land on our docket, what it seems we have is a DFPS lawyer who made no opening, made no closing, had a lead witness who, I guess in the lawyer's estimation or in the department's estimation, sort of went rogue, said the wrong thing that the department did not intend for her to say, but counsel never says, oh, let's go back and correct that testimony. Can't be bothered to give a closing statement. It gives the impression that there is maybe no one who has said, this is the department. Everyone isn't on the same page about what the department's position is. And so is that even happening before the case goes to a hearing like this? Does the lawyer just get to decide on the day of trial whether termination should be on the table or not?
No, Your Honor, that's a collaborative discussion with usually the caseworkers who are managing it, or at least their
Well, we know what the
supervised-
caseworker thought.
Correct.
Yeah, it sure seems like if, to the extent that collaborative discussion took place, which we can have our doubts about that, but let's assume it took place, it seems like the outcome was we're not seeking termination, and that's the case that was put on by the lawyer and the witness. And so going back to my first question, when did that change? Are there some facts that caused that to change? Because you certainly could have reacted to this issue by saying, well, yeah, we confess error. We'll be happy to agree to this lesser judgment that she wants because that's what we wanted in the first place. And so you could have done that. You didn't do that, presumably because you now think termination is better. And so what's informing that change of heart?
Well, I do not believe that the department itself had a change of heart. All of the written pleadings before and after trial, including the pleadings filed in front of this court, confirm that the department has remained steadfast in its pursuit of this claim, other than the 7 lines on the transcript from a caseworker who did not have the authority to abandon.
And other than never saying this is really what we want in clear language to the judge in the entire trial. Other than that, very steadfast.
No closing argument was offered in the case here, Your Honor. That is true. However, everyone at trial knew and understood after the caseworker gave her testimony that termination was still on the table. Mother asked for no termination.
Let me direct you back. I have another question. So recently, or several years ago, the Family Code was amended in 262.201G, which has to do with removal, the initial removal. And the department now must be able to show that the urgent need for protection required immediate removal, and that reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent removal. So that's a pretty high burden. And so as far as what's required of the department in order to remove in the first instance. And so as a result of that, has the department changed its policy with regard to removal and the subsequent pleadings that are filed in response to that removal and what led to that removal?
I do not know the answer to that question, Your Honor. I only know that the state of the law at this time was clear and convincing evidence to prove termination.
On final, yeah, but I'm talking about that relation between the removal and the pleadings. Yeah.
Yes, Your
If the outcome of the trial had been the lesser judgment that the mother now seeks, would the department have appealed and sought termination?
I do not know the answer to that hypothetical. I imagine that whatever the trial court judge ruled for by clear and convincing evidence would have been appropriate. But in this case, that was for termination.
Justice Huddle's question.
And just the follow-up there is that you were engaged in protracted appellate litigation over the difference between the termination judgment and the lesser judgment that is still pretty severe for the mother, and the department is fighting awfully hard for termination over this lesser judgment that's still pretty severe for the mother. And I'm just honestly trying to figure out why.
I believe it's really all about the abandonment issue, because holding that a caseworker who does not have the authority to abandon these claims, at least never has under the department's view, would still have the authority to do that, would set case-ending landmines that any caseworker who generally lacks legal training could step on and accidentally vitiate claims that are otherwise steadfastly litigated.
But the court hasn't held that yet.
No, Your Honor, the court has not held that yet. I also see my
So Justice Blacklock's question, it still stands.
yes, sir.
I had just one more thing, and I've been thinking about the question Justice Huddle asked you, and start off with the point that, of course, this court, we're kind of in a tower here, and we're not seeing the full lay of the land. We get a lot of these petitions, and yet nothing remotely comparable to what our colleagues on the courts of appeals and the district courts have. And so it's hard to tell, is this really just a one-off weird thing, or things like this happening routinely, no opening, no closing, things that we just never see. And so it makes me wonder if it's not really in the interest of everyone. I know you're doing a very good job of defending your client's position, 100%. But would it not possibly be in the long-term interest even of the government, even if you lose this case, to have clarity from this court that attempts to make very clear in all of these trials, and we know how the resources are stretched so thin, and God bless the people on both sides that are working on these terrible, terrible cases. But at the very least, it must be absolutely unambiguous, and any suggestion by an authorized representative of the department that termination is off the table must be responded to forcefully and quickly, or else the department is limited to a still very severe but lesser remedy. Would that not be something useful? You just know it. It'd be there. We would not have to fight about this kind of thing. We wouldn't invest the resources in appeals like this.
Yes, Your Honor. Having a rule that offers clarity would be very helpful, but in this case, even if you find that abandonment occurred for the reasons this court has identified, the issue was still tried by consent. So this termination ruling could still stay in effect while you grant clarity to the abandonment question for that reason. I see that.
Any further questions? Thank you, Mr. Plemons.
Thank you.
Mr. Rowans, you have 5 minutes.
Thank you. I'd like to start off where my friend opposition ended, and that is, assuming that they had abandoned it, then this issue was tried by consent. There was an indication that the Court of Appeals may have bought the department's argument on that issue, particularly because the request I made in closing was not to terminate respondent mother's rights. But the department can't get pled by consent, because in order for an issue to be pled by consent, it has to be an unpled claim, evidence being presented without objection under circumstances where both parties knew the issue was being contested. Now, if the department concedes that it abandoned termination, they can't also say that they knew the issue was being contested. They can't have it both ways and argue the issue was tried by consent. I think it.
So I have it. So you handle quite a few of these cases, is that right?
Yes, Your Honor.
So if, when the state is filed for termination, and that's in the pleading, and the parents see that, I mean, is it your practice that the parents don't really take it seriously, that they think, well, they always plead for termination, so they don't really mean it? Is that what your reality has been with these cases?
I think it depends on what situation the parents find themselves in. When they see termination in pleadings, they typically are very concerned about that.
I mean, when would they not be? Being a parent myself, I can't imagine getting a pleading saying, oh, well, maybe not.
Very true, Your Honor, and the clients that are in these cases find themselves in very difficult situations, and the hope is when they read that their parental rights are subject to termination or further restriction, that kind of kickstarts a change in their behaviors so that they can be a better parent for the children.
Is it ethical to plead for a remedy that you don't honestly believe is justified by the facts at the time in order to achieve leverage over your opponent in litigation?
I do not think that's ethical, but I also believe that the burden to remove children, as Justice Lerman was saying, is pretty high. And so when the department is named as the temporary managing conservator of children, something pretty bad has happened in the family. And so the fact that they always plead for termination, I don't think that crosses an ethical line. I think that is a consequence that very well may occur if the parent doesn't change their circumstances and change their behaviors and provide the child a safe, stable, and appropriate home. And so I don't think they cross ethical lines by pleading that, because they've already met a pretty high burden on being named as a temporary managing conservator. Now, strictly scrutinizing this record, and looking at the direct examination by the department's attorney of the caseworker who was designated as the corporate representative, it's clear they did have a conference before trial. Looking at clerk record 1032, question, okay, what is the department's recommendation of the court today? Answer, the department is seeking to limit and restrict respondent mother's rights and give permanent managing conservatorship of the child to respondent father, and to limit respondent mother's rights to parent non-conservator with no visitation and contact. Next line, next question. What is the reasoning behind that recommendation or request? The caseworker provides some reasoning. Next question. And do you believe that that is in the best interest of the child? Answer, yes, sir. That's not a caseworker going rogue. That's a caseworker testifying pursuant to their pretrial conference on what the department's position was going to be. It's clear. There was no reason for the Court of Appeals to try to interpret that testimony. That testimony was clear, it was unequivocal, and it was a request to the court not to terminate, but to name respondent mother as a parent non-conservator, and that's what respondent mother is asking you all to do.
Any further questions? Thank you, Mr. Rollins. Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.